Greetings of the day to all the learners of Dr. B.R. Ambedkar Open University in Hyderabad. Today, as a part of your course on Principles and Practice of Insurance, we will take up the lesson of policyholders' rights of assignment and nomination. As a insurance policyholder, a policyholder has got different types of rights. You have a right to claim, you have a right to take a loan on your policy, you have a right to complain and get redressal of your grievances. Similarly, you have a right called as right of assignment and right of nomination. So these two rights will be exclusively dealt in today's session. So first, let us have an understanding of what is an insurance contract. So insurance contract is basically one where one party called as an insured or an insurer or a policyholder receives an assurance of compensation from another party called as an insurer or an insurance company, who agrees to compensate the policyholder for any kind of damages or losses which may be suffered because of a future uncertain event that may adversely affect the policyholder. So this arrangement where insurance company is planning to compensate the policyholder is called as an insurance contract. Under this insurance contract, the policyholder will have different types of rights. One significant right that a policyholder has got is called as a right of assignment, right of nomination. So let us see what first assignment means, and then we will go for what is nomination. Life insurance policy can be assigned or is said to be assigned when the rights of one person are transferred to another person. So the process where the rights of a policyholder are transferred to another person is called as an assignment. So the policyholder will be called as an assigner, and the person to whom the rights are transferred will be called as an assignee. So you have assignment as a process where the rights of a policyholder are transferred to another person. The person transferring the right, which is nothing but the policyholder, is called as an assigner, and the person to whom the rights get transferred, he will be called as an assignee. So this arrangement of transferring the rights will be called as your assignment. Now whenever the rights are being assigned, the rights of the original policyholder will be cancelled because he has transferred his rights to the other party. An assignee will become the owner of the insurance policy because rights have already got transferred. So the original policyholder no more stands any rights on the policy. His rights will be cancelled and the assignee will become the owner of the insurance policy. Let us see different types of assignment. With this understanding of what is an assignment, who is an assigner and who is an assignee, let us now come to different types of assignments. In types of assignment, the first one that you have is called as absolute assignment. During the process of transferring the rights, if the rights of the policyholder are completely transferred without any condition, there are no conditions which are attached to this assignment, but complete transfer of the rights happen, the person to whom the policy rights have been transferred gets unconditional rights on the policy, no conditions attached. Then it is called as an absolute assignment. If I had a policy of 1 crore and if I am putting it in the name of a third person, then that person without any condition gets the policy of 1 crore, then such an arrangement will be called as an absolute assignment, no conditions attached. First type. Second one is a conditional attachment. As a part of this assignment, certain conditions must be met before the transfer of rights from the assigner to the assignee. Only if the conditions are met, then the policy will be transferred. Say for example, you had an insurance policy and on that you have taken a loan. So when you have taken a loan on that insurance policy, if the assignment says that the assignment can happen only when the loan gets repaid or loan is repaid to the extent of 70%, only then assignment can take place. Then unless the condition is fulfilled, then assignment will not happen. So in the event that the insurer receives a death benefit which may be exceeding the loan amount, then the bank will be paid first, and then whatever is the difference, then the balance will be paid to the nominee directly. So in case there are any conditions which are being attached, then whenever the condition is being met, only then the assignment will take place. Otherwise the assignment cannot take place. So conditional assignment is one where certain conditions must be met before the transfer of rights from the assigner to the assignee. Now whenever conditions are applied, whenever assignment has to happen, there are certain points to remember. There are certain considerations for assignment. So let us see what all are these considerations for assignment. Now a policy assignment basically will transfer or change the ownership, but not the risks which are associated with it. So whoever is the person to whom you are transferring the policy, not only ownership gets transferred, but all kinds of risks which are associated also will get transferred. So a policy assignment transfer or changes only the ownership and not the risks associated with that. The person assured therefore becomes the person insured. So whoever is the person to whom the assignment was happening, which is called as the assignee, that particular person will become the insured. So it changes the ownership but does not change the risk associated. All risks associated are the same. Then assignment will lead to cancellation of the nomination. Whatever was the nomination which was there in the earlier policy, now when the policy gets assigned, then that nomination which was there in the original policy also gets cancelled. Say for example, a policy I took in my name, I kept my spouse as a nominee in the policy. So if anything happens to me, he will receive the benefit. But during the course of the policy, I have assigned the policy to my son. Now when I have assigned the policy to my son, the nominee was earlier my spouse, which now stands cancelled because I have assigned the policy to my son. So now it is in the favor of my son for him to take whomever he wants to take as a nominee, but original nomination will stand cancelled. So in assignment will lead to cancellation of the nomination. So whoever was the original policy holder, that particular person must have had somebody given as a nominee. That nomination will be cancelled when assignment takes place, because now the assignee, whoever is the new policy holder, he will have a right to have his or her own nominee in the policy. So therefore the original nomination will stand to be cancelled. Then assignment can happen for all types of insurance policies. Any insurance policy you take, assignment can happen except for two policies. One is a pension plan, where the pension holder only will be the receiver. He cannot transfer the pension policy to anybody else. Whoever is the pension holder, the policy will go only in that particular person's name. If I am the pension holder, unless I die, when the it may get transferred, but otherwise it will not get transferred to anybody else during my lifetime. So I cannot assign a pension plan to anybody else because it is exclusively in my name. Similarly, Married Women's Property Act, MWP, under that also if anything was taken as an insurance policy as a part of Married Women's Property Act, even then also assignment cannot take place. So in these two plans, that is your pension plan and Married Women's Property Act, assignment cannot take place. Except for these two, any other policy the person may take, endowment policy, marine policy, fire insurance, any policy that I may take, I have a right to transfer that particular policy to another person, but except for these two. And whenever assignment has to take effect, endorsement should happen. So a policy contract endorsement is required to effect the assignment. I have to inform the insurance company will have to do the needed documentation, and all the signatures and all the papers have to be filed properly, and only then assignment can take place. So a policy contract endorsement is required for assignment to take effect. I simply cannot sit in my home and say that I have assigned the policy. I have to bring it to the notice of the insurance company. They have to carry on the necessary documentation process, and only then assignment can happen. So a policy contract endorsement is required to effect the assignment. So for consideration of assignment, the first thing to remember that assignment transfers the ownership and does not changes all the risk associated with it. Risk associated with the policy remain the same, only ownership is transferred, and cancellation of the original nomination will happen whenever assignment takes place. All policies can be assigned except Pension Plan and Married Women Property Act, and unless endorsement happens, assignment cannot take into effect. This is the first type of a right which a policy holder has got, which is called as a right of assignment. When I am transferring the right of my policy to another party, I am the policy holder, I am called as assigner. The person to whom I am transferring the right is called as an assignee, and the whole process of transferring this right is called as a process of assignment. If I have no conditions attached to the assignment process, it is called absolute assignment. If I have any conditions attached to the process of transfer or assignment, it is called as a conditional assignment. And you have to remember that ownership gets transferred, risk remain the same, original nomination will be cancelled, endorsement will have to take place, except for Pension and Married Women Property Act, all other plans can be assigned. This is your first part, policyholder rights of assignment. The second is policyholder's right of nomination. Nomination is the right which is given to the policyholder, which is authorizing the policyholder to appoint a person. Usually a close family member is appointed to receive the benefits in the event of death of the policyholder. If the policyholder dies, because the policyholder must have paid certain premiums, then the benefit of the policy should come to the close family member or any person who is appointed as a nominee. So the right which is given to the policyholder, which is authorizing him to appoint a person in the event of his death to receive the benefit of the policy, then this process is called as a process of nomination. The person who is appointed by the policyholder to receive the benefit will be called as a nominee. Whomever, if I have a life insurance policy in my name, if I have kept my son's name as a nominee, as a person to receive the benefit, then the son will be called as a nominee. The process of giving him the authorization to receive the benefit in the event of my death will be called as nomination process. So, right given to policyholder to authorize him to appoint a person for receiving the policy benefit in the event of my death will be called as a process of nomination. The person who will receive the benefit is called as a nominee. Now, basically under life insurance, the process of nomination is very popular, where the policyholder will nominate a person who is entitled to receive the benefit in case something happens. Under this, you have nominees, different types. The first type is a beneficial nominee. As per the law, immediate family member, that is the spouse, children or parent, they will be nominated by the policyholder to receive the monetary benefit or any other benefit or claim benefits which may come on account of the policy. It is important to note that beneficial nominees will be the immediate family members only. So, spouse, children or parents, blood relatives who are immediate family members only will be called as a beneficial nominee. Sometimes a policyholder may appoint children as beneficiary of their life insurance policy. Such people, such children will be called as minor nominee. So, nominees who are less than the age of 18 years, they are not considered eligible by law to handle any claims. So, in case any claim amounts and all are there, children below the age of 18 are called as minors, and as minors they are not competent to contract as per the Indian Contract Act also. So, therefore, minor nominees who are less than 18 years of age, they are not considered eligible to handle claim amounts. So, therefore, policyholder will have to assign or appoint a custodian or an appointee. So, the claim amount will be paid only when the minor will turn 18 years of age. So, minor nominees are also being given by most of the policyholder as a nominee. Then you have sometimes nominees who can be non-family members. So these type of nominees can be distant relatives, they can be friends who can be beneficiaries of your insurance policy. So such people can also be nominated. It is a choice of the policy holder. Then changing nominees. Policy holders can also change nominees depending upon time to time, or depending upon their wish. They can change the nominees from time to time. Whoever is the latest nominee whose name you have changed, they will supersede all the previous nominees. So if I have, when I have took the policy, probably I must have given my spouse's name, but my policy is for 15 years. So at the end of the 10th year, I feel that my son should receive the benefit. Then I will change the name, nomination in the name of my son. So the latest nominee is the son now. So the previous nominee was the spouse. So now that changes. So all previous nominees will stand cancelled when you have given the latest nomination. So you have a provision of changing your nominees also in your insurance policy. Now whenever a nomination has to take place, in order to nominate, whoever is the policy holder and whoever is the life assured, both of them must be the same. Say for example, sometimes I take a policy in the name of my parents, but their life assured is my parents. So here the policy holder and the life assured are different. So in such a case, in order to nominate, the policy holder and the life assured must be the same. In case of a different policy holder and a life assured, the claim benefits will be paid to the policy holder. Whoever is the policy holder, the benefits will be paid to them only. And one policy can have more than one nominee also. It's not necessary that you have to put only one person as a nominee. You can have more than one person also whose name can be given as a nominee. Sometimes on account of successive nominations, if a life assured appoints person A as the first nominee to receive the benefit, in case person A who has to receive the benefit also dies, life assured died, person A also dies, then you can have a successive nomination of person B who can get the claim. If A also dies and B also dies, then you can also have person C who can be a successive nominee. So you can have successive nominations also whose names you can give. So in the event of the death of the life assured, if first nominee also dies, then successive nominations can also be given by a policy holder. So like that you can have successive nominations which can be given. Now nomination and assignment, both of them are rights only of the policy holder, but both of these rights differ to some extent. So let us see what are the differences between the right of nomination and right of assignment. Nomination means appointing a person by the policy holder to receive the benefit. Whatever are the benefits of the policy, when the policy holder is appointing a person to receive the benefits of the policy, in the event of the death, then it is called as nomination. Whereas assignment is giving away the right. You are giving away the right, you are giving away the title, you are giving away your policy to somebody else. So it is not giving away the benefit to your person whom you have nominated, but the policy itself is not in your name. You are giving away the policy, giving away the right, the title, the claims to someone else. So nomination is appointing a person who will receive the benefit, but assignment is transferring the right, title, interest of the policy to another person. So you have the meanings which are different here. Nomination is different and assignment is different. In assignment, policy holder will not have any rights after assignment is over. Once you have assigned, the policy is no more yours. But in nomination, you are only nominating that if you die, who will receive the benefit. So policy is yours only. Policy holder has all the rights on the policy except that he has nominated somebody to receive the benefit in case of the death. So you have the meanings there, right of nomination and right of assignment. Then what is the purpose? Why do you nominate or why do you assign? Now the purpose of nomination is to help the beneficiary to recover the policy amount when it becomes due for payment. So when the policy holder has died, whoever is the beneficiary who has to receive the policy amount, then it becomes due for payment. The purpose of nomination is that the beneficiary should receive the benefit. Whatever was the benefit on the policy, if the policy holder dies, then whoever is the nominee whoever is the beneficiary, they should not miss out on the benefit. They should receive the benefit from the insurance company as and when the benefit becomes due. So the purpose is to help the beneficiary recover the policy amount. Whereas in assignment, the purpose is transferring all the rights and interest in the favor of the assignee. Whoever is the assignee, you have transferred all the rights and interest in their favor. Then in case of nomination and assignment, attestation, endorsement is necessary for assignment, but attestation is not necessary for nomination. When the policy document is made, you simply give somebody's name as a nominee, or later also you can keep on changing your nominees. So attestation, endorsement is not necessary. But in case of assignment to happen, endorsement or attestation becomes very, very essential there. So attestation is not required in nomination, but attestation is required in assignment. Then consideration. Nomination does not involve any kind of a consideration. I am simply naming somebody to receive the benefit. But in case of assignment, because I am transferring the entire policy to somebody, I may receive something in return. So say for example, if I took a policy on my property and I am transferring the policy to somebody else, then whatever is the policy that I am transferring, I may receive something in return because I am transferring this insurance policy in the name of XYZ. So that XYZ may give me something in return. There could be some kind of a contract for assignment. So in case of assignment, consideration will be involved, but in case of nomination, consideration is not involved. That means consideration means something in return. So when you nominate a person, there is nothing in return that you will get. But when you assign a policy, you are giving away the policy to somebody. So when you give away the policy to someone, that person may pay you something in return. So that is called as consideration. So assignment may involve consideration, but nomination will not involve any kind of a consideration. Then right to sue. In the court of law, nominee has no right to sue the policy holder. I keep on changing the nominees. A particular nominee cannot hold me responsible for and say that you cannot change your nomination. They cannot sue me in the court of law. But an assignee has a right to sue in the court of law. And because nomination also stood cancelled. Say for example, original policy was in my name, I nominated my spouse. Now I assigned the property in the name of my friend, the policy in the name of my friend. Now my friend, when my nomination stands cancelled now my spouse cannot file a case in the court of law and say that he stands as a nominee on my policy because it was assigned. So therefore the right to sue will be lost there. So here nominee has no right to sue under the policy, but assignee, because assignee is now the new owner of the policy. So assignee has right to sue under the policy. If there are any loans which were taken for which the original policy holder is liable to pay back the loan, then assignee has a right to sue him under the court of law. So right to sue, right to take the original policy holder to the court of law is there in case of assignment, but right to sue is not present in case of nomination. So right to sue is not there under nomination, but right to sue stands in the case of assignment. Then revocation. Revocation means changing or cancelling. So nomination can be changed, or it can be cancelled, or it can be revoked several times. If you have an insurance policy for 15 years, then you can keep on changing your nomination throughout a period of 15 years. But assignment can be revoked only 1 or 2 times. You cannot keep on assigning throughout the term of the policy. The insurance company will put a limit on the number of assignments which can take place. So assignment can be revoked 1 or 2 times during the term of the policy. Then usually nomination is made in the favor of immediate relatives, whoever are your family members or your immediate relatives, your children, spouse, parents, only in their name usually nomination happens. But assignment can be made in favor of immediate relatives. It can also be made in the favor of external parties also. External parties who can be lenders, who can be creditors. In their name also you can transfer your policy. So assignment can be in the name of external party, not only immediate relatives as such. So that way you have the differences between assignment and nomination. So basically throughout the course of this particular session, we have seen what are the rights of a policy holder in case of assignment and nomination. So policy holder has different types of rights, but these two rights stand very essential on a contract, where you have a right to assign or to transfer the rights from yourself to another person through the process of assignment. You will be the policy holder called as an assigner. You are transferring your rights to another person called as an assignee. So that particular person will become the new policy holder now. So the rights of the original policy holder will be cancelled whenever assignment takes place. And for assignment to take effect, endorsement or attestation is very, very essential there. And if assignment does not have any conditions which are attached to it, it is called as absolute assignment. But if there are any conditions attached to it, then you call it as a conditional assignment. And you have to remember that ownership is transferred, risk associated remains the same. Whatever was the original nomination, that original nomination will stand cancelled because you have transferred the policy in the name of another person. So whomever you nominated to receive benefit, that will stand to be cancelled. Except for pension plan, except for Marriage Women Property Act, all other policies can be transferred, that is, they can be assigned. Then nomination is one right which is given to the policy holder, where he or she can actually appoint somebody to receive the benefit in the event of your death. So when the policy holder dies, when you are appointing somebody to receive the benefit on your policy, then that particular person will be called as a nominee, and the process of appointing that person to receive the benefit will be called as a process of nomination. Usually the close family members who are called as beneficial nominees, that is your spouse, your children, your parent, they will be called as beneficial nominees. Sometimes you can also have minors who can be nominees, who can be given. So you can have people who are less than 18 years of age. They cannot handle claims, so you have to also put a custodian in their name. They can claim the amount only when they are turning 18 years of age. So you can also have minors as nominees. You can also have non-family members, where relatives, friends can also become beneficiaries of your policy. And throughout the term of your insurance, you can keep on changing your nominees, and whoever is the latest nominee, that person will supersede all previous nominees who are there. And whenever you have to nominate, you have to see to it that policyholder and the life assured are one and the same, and you can have more than one nominee. You can also have successive nominations. If the first nominee also dies, then the second nominee will receive the benefit. If first and second nominee both die, then the third person can receive the benefit. So you can have successive nominations also which can be done. So in today's session of rights of a policy holder, we have seen these two prominent rights which are there, and we have also seen some of the differences which are there between nomination and between assignment. So this session spoke about what are the rights of a policy holder in terms of nomination, appointing a person to receive the policy benefit in the event of death, assignment, giving away the right of title and interest to another person, basically nomination done to receive the benefit, assignment done to transfer all the rights, attestation not required for nomination, but attestation is required for assignment. Nomination may not have any kind of a consideration. The person will not receive anything in return. But in case of assignment, the policy holder will receive something in return. And whenever you have a right to sue, the nominee has no right to sue, but an assignee will have a right to sue. And all these nominations usually are done in the name of your immediate relatives, but assignment can be done in the name of immediate relatives, or it can also be done in the name of the external third party. So as a policy holder and as a learner of this particular course of Principles and Practice of Insurance, these two rights of a policy holder are very essential to remember. The right of a nomination, naming a person to receive the benefit on your policy, and right of assignment, where you can transfer your policy in the name of somebody else. So we have covered these two rights in today's session. Thank you so much.